All right, let's dive into something that's really been heating up again.
Yeah, it feels familiar, doesn't it?
It does. Just last month, August 2025, this whole debate around the American flag, one of our most powerful symbols, it just flared right back up.
And it kicked off with that executive order from President Trump.
Exactly. He directed his attorney general to, and I'm quoting here, vigorously prosecute those who violate our laws in ways that involve desecrating the American flag.
Which sounds straightforward, but it's actually aiming higher, isn't it?
Much higher. The order explicitly says the goal is to tee up a challenge for the Supreme Court, basically asking them to rethink and maybe even overturn their past decisions protecting flag burning as free speech.
And this wasn't in a vacuum. It followed some specific incidents.
Right. There were flag burnings during recent anti-Israel and anti-IC protests. So we're back facing these really deep questions about free speech versus, national identity, the fabric of our laws.
It's way more than just a piece of cloth. It's this decades-long clash. National reverence versus individual expression.
So today, we're really asking, when does protest cross a line into disrespect that the law should forbid? And, maybe more importantly, who gets to decide that?
To really get a handle on this executive order and, potential legal fight brewing, we have to go back, way back to 1989.
Okay, what happened then?
Well, June 21st, 1989. That's when the Supreme Court handed down a really pivotal 5-4 decision. The case was Texas v. Johnson.
Texas v. Johnson. I remember the name. Who is Johnson?
He was an activist, Gregory Lee Johnson. And he'd been convicted under Texas state law.
For what?
For burning a U.S. flag during a protest. This was back in 1984, outside the Republican National Convention in Dallas.
Okay, so Texas had a law against flag burning. What was their argument for upholding that law, and how did the Supreme Court respond?
Well, Texas argued essentially two main things. First, that the state has a strong interest in preserving the flag as a sort of venerated national symbol.
Makes sense. And the second?
And second, that they needed the law to prevent breaches of the peace, stop fights from breaking out.
Right. So how did the court see it?
The court, in a majority opinion written by Justice Brennan, actually sided with Johnson. They leaned heavily on the First Amendment.
The free speech part.
Exactly. Brennan wrote that the First Amendment's protection does not end at the spoken or written word, meaning some actions, symbolic actions like flag burning, count as speech.
Okay, so it's symbolic speech. What about the breach of peace idea?
They looked at the facts of Johnson's case and said, basically, there wasn't an actual riot or imminent threat of one. So that argument didn't fly either.
Wow, a 5-4 decision. That sounds like it must have had a massive impact then, not just for Texas.
Oh, absolutely monumental. It didn't just strike down the Texas law. It effectively wiped out similar flag desecration laws in 47 other states, too.
47, so almost everywhere.
Pretty much. It sent this really clear signal nationwide. The government, generally speaking, can't ban burning the flag just because it's a form of protest.
That's a strong statement.
It is. And Justice Kennedy, who was in the majority, wrote this really interesting concurring opinion. He basically said, look, sometimes the law forces us to make decisions we don't personally like.
Because the Constitution demands it.
Exactly. He said we have to uphold the Constitution as we see it, even if the outcome feels, well, uncomfortable. It really captured the tension.
But a 5-4 decision means there was strong disagreement, right? Who was arguing the other side on the court?
Oh, definitely. Chief Justice Rehnquist wrote a powerful dissent. He famously called flag burning an inarticulate grunt or roar.
Strong words.
Very. He argued it was just a deeply offensive act, plain and simple, and the government should absolutely be able to prohibit it. His dissent really highlights how divided the court and probably the country was on this.
So the court says flag burning is protected speech. How did that go down with the public and Congress? Was there immediate pushback?
There was a really strong reaction. Almost immediately after Texas v. Johnson, Congress jumped in and passed the Flag Protection Act of 1989.
Trying to do through federal law what the states couldn't?
Precisely. They tried to create a national ban. But it didn't last long.
What happened?
Just a year later, 1990, the Supreme Court took up another case, United States v. Eichmann. And again, 5-4, they struck down the federal law too.
Same reasoning.
Pretty much the same reasoning.
Yeah.
They said the law was still aimed at suppressing expression, and that violates the First Amendment.
Okay, so federal law fails, state laws failed. What's left for those who really want to protect the flag from being burned?
Well, that's when the conversation really pivoted. The next logical step, for many, was to change the Constitution itself.
A constitutional amendment. That's a huge step.
It is. And figures like Senator Orrin Hatch really championed this. He called the court's decisions a striking judicial misinterpretation that ignored, like, 200 years of history.
So he saw it as the court getting it wrong.
Fundamentally wrong. He argued the only legitimate way to settle this, if the court wouldn't, was through the formal amendment process laid out in the Constitution, not by judges deciding.
Did they actually propose one?
They did, several times. For instance, in 1999, Senator Hatch co-introduced the Flag Protection Amendment. It was Senate Joint Resolution 14. Its whole point was to give Congress back the power to ban physical desecration.
And was this just a Republican thing?
Not entirely. It's interesting. Senator Max Cleland, a Democrat, a decorated Vietnam veteran, he was actually a lead co-sponsor. He spoke about his sadness that the earlier laws were struck down. So definitely cross-party lines for some.
Let's dig into that side more. What are the core reasons proponents give for why we need to allow Congress to ban flag desecration? What's at the heart of their argument?
A lot of it comes down to the flag's immense symbolic weight. It's seen as representing national unity. The sacrifices made for the country are core values.
Can you give an example?
Sure. Think about Senator John McCain. As a POW in Vietnam, he talked incredibly movingly about how the flag was a vital symbol of morale and resistance for him and others in captivity. Yeah. And there's another powerful story from Ulteen General Edward Baca about a WWII POW, Jose Quintero. He secretly made a flag in the prison camp, waved it, risked his life, but he gave his fellow prisoners immense hope.
So it provides hope, strength, and endurance, as they say.
Exactly. And proponents point out that statistically, more medals of honor have been awarded for heroism involving the flag than for almost anything else. For them, it's just not abstract. It embodies real sacrifice.
So it's deeply tied to sacrifice and shared experience, and it sounds like there's also a concern about what allowing flag burning teaches, especially younger people.
That's a big part of it, too. Senator Hatch argued it wasn't just mere symbolism. He said it was about values and principles and building a national community. He had this line, "Liberty that does not rest on a foundation of community rests on sand."
Implying individual rights need some grounding in shared values.
Precisely. There's this strong belief that protecting the flag helps instill patriotism and community values. You had teachers like Maribeth Seeley worrying that allowing flag burning sends the wrong message to our youth, signaling a lack of respect.
And some military figures felt strongly, too.
Oh, yes. Major General Patrick Brady from the Citizens Flag Alliance was very blunt. He said allowing flag burning teaches our children disrespect, suggests outrageous acts of a minority are more important than the will of the majority, and basically tells people that the courts own the Constitution, not the people or Congress.
That point about who owns the Constitution, the courts, or the people seems really central to their argument for an amendment.
It really is a key tenet. Scholars like Professor Richard Parker argued an amendment would simply restore its pre-1989 meaning to the First Amendment. It was framed as reclaiming the people's will.
Through their elected representatives.
Exactly. Senator Hatch constantly emphasized that the amendment process is the correct constitutional way to make changes, especially when you believe the judiciary has overstepped.
And they felt there was popular support for this.
They certainly argued there was. Hatch pointed out that at one point, the legislatures of 49 states had actually passed resolutions urging Congress to send a flag amendment to them for ratification. That shows pretty widespread feeling at the state level.
Interesting. And some saw it as even more fundamental.
Yeah. Professor Stephen Presser went further. He linked the Johnson decision to what he saw as a fundamental misunderstanding of the American founding. He argued individual liberty had, quote, spun almost out of constitutional control, leading to a decline in national standards. For him, the amendment was a way to rebalance rights with responsibilities.
Okay, that's a clear picture of the arguments for protection. Now let's flip the coin. What are the main arguments from those who strongly oppose a constitutional amendment to ban flag burning?
The absolute core concern for opponents is protecting the First Amendment itself. Senator Patrick Leahy put it starkly. He argued an amendment like this would be the very first restriction on First Amendment rights in all of American history.
The first time the Bill of Rights itself would be amended to limit a right.
Exactly. He drew comparisons to countries like Cuba, saying criminalizing offense to the flag is a response of weakness, not strength. The belief is that real patriotism can't be forced. A free society needs more speech, not enforced silence.
And this brings up that slippery slope idea we hear about sometimes, doesn't it? The fear that once you start limiting one form of expression,
Absolutely. That's a huge worry for opponents. Senator John Glenn, a veteran astronaut, a national hero, he strongly opposed the amendment for this very reason.
Yeah.
He warned about a slippery slope.
Where does it end?
Right. If Congress starts restricting political expression, where do you draw the line? He made the powerful point that the First Amendment survived the Civil War, World Wars, economic depressions, even the Vietnam War era, when flag burning was arguably much more common, without being changed.
So why change it now?
That was his point. And Randolph Moss, from the Justice Department back then, echoed this. He called amending the Bill of Rights an ill-advised departure from history, even bringing up James Madison's warnings about tinkering with the Constitution too often.
And he had that memorable line.
Yeah, the really famous one. The flag symbolizes our nation. But we must love the Constitution even more, because the Constitution is not a symbol. It is the thing itself.
That really crystallizes the opposing view, prioritizing the foundational document over the symbol. What about practical problems? Did opponents see issues with actually trying to enforce a ban?
Oh, definitely. Big practical problems. Senator Glenn asked, how do you even define desecration? Is a flag on a bikini desecration? What about a worn-out flag bumper sticker? A kid's crayon drawing?
Yeah, where's the line? And intent must be hard to prove.
Extremely hard. What if someone burns a flag respectfully to retire it, but they also happen to be protesting, say, tax policy at the same time? How do you prove their intent was desecration?
It sounds like a legal nightmare.
It does. And Senator Bob Kerrey, another Medal of Honor recipient, worried about unintended consequences. He suggested a ban might actually encourage more flag burning by giving protesters easy publicity.
And potentially divert police from other issues.
Right, taking resources away from more serious crime.
It also sounds like some opponents question whether this was even a widespread problem that needed such a drastic solution, like a constitutional amendment.
That's true. Senator John Chafee pointed this out. He argued there simply wasn't a rash of flag-burning incidents. He used Congressional Research Service data showing only about 43 reported incidents over a 4-year period in the late 90s.
43 incidents in 4 years, across the whole country.
Yeah, he basically called it a solution looking for a problem. Walter Cronkite chimed in too, criticizing the effort as just trying to punish a handful of immature flag-burning hooligans who were a real threat.
And some argued the focus should be elsewhere.
Yes, particularly on supporting veterans in tangible ways. People like Senator Leahy and veterans like Gary May made the point that maybe Congress should focus more on health care funding for vets rather than arguing over mere symbolism. May noted many veterans didn't want the freedoms they fought for traded away to protect a physical object.
Okay, so all this history, these passionate arguments on both sides, it really brings us back to the present day, doesn't it? How has this shaped the political landscape we see now?
Well, you can really see how the flag debate has become intensely politically coded. It's not just about the law, it's about identity and politics.
How so?
Since the Vietnam era, broadly speaking, conservatives have often positioned themselves as the primary defenders of patriotism, associating the flag, freedom, independence strongly with the Republican Party platform.
And liberals.
There was maybe a brief moment after 9/11 where patriotism felt less partisan, where it seemed safe for liberals to be patriots, as one analysis put it.
Yeah.
But that didn't last long. Often, opposition to certain government policies gets framed, fairly or unfairly, as being anti-patriotic. The flag becomes a shorthand in those debates.
And President Trump's recent executive order trying to reopen this legal battle, it fits right into that dynamic, doesn't it?
It really does. Notice how he frames it. Flag burning as a public safety issue, because it supposedly incites riots. He's looking for an exception to First Amendment protection based on conduct, not just speech.
Trying to find a legal angle the previous courts didn't accept.
Essentially, yes. Arguing that if the act of burning incites violence or breaks other laws like fire codes, then it's no longer protected speech. But legal experts push back hard on this. They argue first, a president can't just rewrite the First Amendment or overturn Supreme Court decisions with an executive order. That's not how it works. And second, existing laws already allow prosecution if someone creates a genuine public safety hazard while burning something, whether it's a flag, a tire, or anything else. The danger is the issue, not the symbol being burned.
So if this does end up back at the Supreme Court, it would be a huge deal, not just for the flag issue itself.
Oh, enormous. It would be a major test of stare decisis.
Which is?
That's the legal principle of respecting established precedents, sticking by previous decisions. It's fundamental to how our legal system provides stability.
And there's debate about how much weight that should carry.
Absolutely. You have justices like Chief Justice Roberts, who reports suggest has sometimes voted with the majority, even when he might personally disagree, specifically out of respect for precedent, for stare decisis.
But not all justices feel that way.
No. Others, like Justice Clarence Thomas, have indicated much more willingness to revisit and potentially overturn long-standing precedents they believe were wrongly decided. He actually cited Rehnquist's dissent from Texas v. Johnson in a later opinion about cross-burning.
So there's an opening there, potentially.
There is. It connects to broader legal philosophies like popular constitutionalism, the idea that the people should have more say in interpreting the Constitution, and originalism, which focuses on the text and historical understanding. These ideas are often favored in conservative legal circles and could fuel a push to overturn Johnson and Eichmann.
Wow. Okay, so from the battlefield to the highest court, it's clear the American flag carries immense weight and sparks deep conflicting emotions. This whole deep dive really lays bare that constant tension, doesn't it? Between honoring a symbol of unity and fiercely guarding the very freedom that allows even deeply unpopular protests.
It really does. It's a fundamental American dilemma.
So as we wrap up, the question we leave with you, the listener, is this. What does true patriotism ultimately demand? Is it unquestioning reverence for national symbols like the flag? Or is it an unwavering commitment to the constitutional freedoms that protect even the kinds of dissent that many find offensive? Something to think about.